Imagine running a rural hospital
Mm.
in a remote part of India. You provide a patient with free life-saving medicine, and as they walk out the door, you hand them a religious pamphlet.
Right.
In most of the world, I mean, that exact sequence of events is simply viewed as faith-based charity. But in several Indian states today, that exact scenario could trigger a police investigation.
Yeah, a police investigation, a frozen bank account, and even the permanent seizure of your hospital's assets.
Right.
The contrast is jarring. It illustrates perfectly how a seemingly simple act of charity can suddenly collide with this massive, complex legal apparatus.
And that collision is our mission for this deep dive. Today, we're opening an incredibly dense research dossier on India, specifically disentangling how two very distinct legal frameworks operate.
Right, because you have to look at them separately first.
Exactly. So on one side, we have state-level anti-conversion laws.
Yeah.
And on the other side, we have a national financial tool known as the Fcra, or the Foreign Contribution Regulation Act. So our goal is to understand how these two systems impact Christians in India.
And these two frameworks are often discussed in the same breath. But to truly understand the landscape, we have to see how they interact. The temperature around this topic is always running high.
Very high, yeah. Which is exactly why we need to establish our ground rules right out of the gate. This deep dive is not taking political sides.
Right, absolutely.
We aren't here to validate extreme opinions on the left or the right. Our mission today is to strictly disentangle the proven facts, the documented allegations from human rights groups, and the official government rationales.
Right. We want to lay out the mechanics of what is actually happening. So to be well informed here, we must start at the absolute baseline, which is the constitutional foundation of India.
Okay.
If we look at the Indian Constitution specifically, Articles 25 and 26, the baseline is actually very robust. Article 25 guarantees the right to freely profess practice. And this is a crucial legal word here, propagate religion.
Propagate. Okay, I want to highlight that word because that means Christianity, its practice, and actively sharing its message are completely 100% legal in India. There is actually no single national ban on Christianity or like a national anti-conversion law.
Right. The protection is baked into the founding document. A person's right to voluntarily choose and practice their faith is fundamentally protected.
So the constitutional property line seems clear enough.
Right.
But if the Constitution is so clear, it begs the question, where does the friction come from?
Well, the dossier points heavily to this patchwork of state-level freedom of religion laws. Several states have enacted their own legislation designed with a very specific stated purpose.
Which is what exactly?
Their official intent is to stop religious conversions that happen via force fraud, coercion, misrepresentation, and here are the two words that cause almost all the legal friction.
Okay.
Allurement or inducement.
Okay. I can understand the first few. Force and fraud are universally understood legal concepts. Holding a weapon to someone's head is force.
Right, obviously.
Forging a baptismal document is fraud. But allurement, that feels incredibly subjective.
It is.
Let me throw an analogy at you. If a marketing company sends me a free sample in the mail to get me to switch coffee brands, that is clearly an inducement. It's a transaction.
Sure.
But if a Christian hospital gives free medical care to a village or a church runs a free school, where is the line between standard religious charity and a legal allurement to convert?
You have zeroed in on the absolute hardest question in this entire debate. What is the exact boundary where a legitimate religious activity becomes an unlawful inducement?
Yeah.
The U.S. State Department's Religious Freedom Report notes that in some of these state frameworks gifts, the promise of a better life, free education, or material benefits can potentially fall under that umbrella of prohibited allurement.
That feels like a paradox, though. I mean, the very nature of humanitarian charity is about providing a material benefit or a better life to someone who needs it.
Which explains the deep concern among Christian organizations and religious freedom groups. Charity doesn't automatically equal illegal conversion. However, if a charitable activity is suspected of being used as a transactional tool for conversion, it stops being a private religious matter and becomes a question for law enforcement.
Wow. If the line is that blurry, I want to know how a state actually monitors and enforces it. Let's look at a concrete example from the dossier.
Okay.
Like the 2021 Uttar Pradesh Prohibition of Unlawful Conversion of Religion Act.
Mm-hmm.
How does the actual machinery of this law work on a normal Tuesday?
So Section 8 of the Uttar Pradesh law provides a perfect case study in these mechanics. If a person wants to change their religion, they cannot just quietly undergo a spiritual shift. They are required to give a 60-day advance declaration to the district magistrate.
Wait 60 days?
Yes, 60 days.
That is 2 months of mandatory waiting just to legally register a deeply personal spiritual decision with the local government.
And the bureaucracy goes further. The religious converter, which would be the pastor, priest, or individual performing the conversion ceremony, they must also submit a 30-day advance notice to the district magistrate.
So we have a massive paper trail required before a conversion can even take place. What does the government do with all this paperwork?
Once those notices are filed, the district magistrate has the authority to order a police inquiry to determine the real intention, purpose, and cause of the proposed conversion.
I have to pause on that.
Yeah.
On a purely human level, spirituality is intensely private.
Very much so.
Introducing a formal police investigation into a deeply personal spiritual decision, it seems inherently designed to discourage people from making those decisions. Having law enforcement knock on your door to interrogate your soul is a massive deterrent.
And human rights groups make that exact argument. They view this level of state surveillance over personal conscience as a deliberate chilling tactic. But the government conversely argues that because forced and fraudulent conversions historically target the most vulnerable, impoverished, and marginalized populations, the state has a moral and legal duty to verify that these life-altering decisions are truly voluntary and not bought or coerced.
I hear that, but the method they use to verify it flips a fundamental legal concept on its head. The dossier flags something called the burden of proof. And I think this is where the legal reality gets truly concerning for these religious workers.
It really does.
In most democratic justice systems, the golden rule is innocent until proven guilty. The prosecution bears the burden of proving that you committed a crime. But here the burden is shifted.
The shift is profound. In several of these state anti-conversion frameworks, the person accused of carrying out an unlawful conversion, so the pastor or the religious worker, they must prove to the court that the conversion was not unlawful.
So they bear the burden of proving a negative.
Exactly. And the U.S. Commission on International Religious Freedom, or USCIRF, has heavily criticized this mechanic, noting that it places an extraordinary, almost impossible legal weight on religious minorities.
If the burden of proof is shifted against the accused and the definition of allurement is incredibly murky, how does this play out day to day? Because that combination seems highly vulnerable to weaponization.
The vulnerability skyrockets when you examine who is allowed to make these accusations. In some states, the law allows third parties to file a police complaint.
I noticed the dossier uses the acronym FIR quite a bit in these scenarios, which stands for First Information Report.
Right.
My understanding is that an FIR isn't just a casual tip line, it's the critical first step that officially initiates a formal, full-blown criminal investigation in India. And you're saying a third party can file one?
That is correct.
Meaning someone who wasn't even involved in the conversion?
Yes. A neighbor, a local activist, or a member of a nationalist group, someone completely outside the religious transaction, can file an FIR alleging that a forced conversion is taking place. And then the police are obligated to investigate. The U.S. State Department report highlights an incident in Chhattisgarh where a private prayer meeting in a family's home was interrupted by a crowd objecting to the meeting.
In a private home?
Yeah. The crowd made allegations of conversion, which resulted in immediate police intervention.
We see reports citing large numbers of arrests, particularly in states like Uttar Pradesh. Advocacy groups point out that Christians and Muslims are frequently the subjects of these complaints, while cases alleging unlawful conversion to Hinduism are virtually non-existent.
That's true, but while the arrest numbers are significant, a vital factual distinction must be made here.
Okay.
Arrest does not equal conviction. When international news outlets cite hundreds of arrests, it simply means an FIR was filed and a police investigation was initiated. It does not mean that a judge examined the evidence and concluded a forced conversion actually occurred.
Let me synthesize what that means for a person on the ground then. A pastor can be arrested based on a third-party allegation, spend their meager savings on lawyers, endure months of stressful court proceedings and social stigma, only to have a judge eventually throw the case out due to lack of evidence.
And that gap between arrest and conviction is where the real systemic damage occurs. Even if a pastor is entirely cleared, the process itself becomes the punishment. The legal fees, the interrogations, the reputational damage in a tight-knit community, it takes a massive toll.
Which creates what critics call the chilling effect.
Yes, exactly.
If I'm running a small Christian charity, and I know that simply handing out a free meal while being a known Christian could trigger a third-party FIR and ruin my life for a year, I might just stop handing out meals entirely.
Right, you just don't take the risk.
Legitimate charity shrinks, not because it's officially banned, but out of sheer self-preservation.
Self-censorship driven by fear of the legal apparatus is a very powerful force.
So if local police and FIRs are how the state handles individuals, the local pastors and believers, it begs the question of how the national government handles the massive institutions backing them up.
The organizations themselves.
Yeah, the nationwide relief organizations, the sprawling hospital networks, the schools. That requires a totally different legal tool, which brings us to the FCRA.
The Foreign Contribution Regulation Act. Enacted in 2010, the FCRA is a completely different animal than the anti-conversion laws.
Okay.
On paper, it is entirely religion neutral. Its purpose is to regulate foreign funding coming into India for any NGO, charitable organization, or association. The government's stated intent is straightforward: ensure that foreign money isn't used for activities detrimental to India's national interests.
But the stakes for Christian organizations regarding the FCRA are existential. I mean, many of these groups rely heavily on foreign donations from churches and philanthropists in the U.S., Europe, and elsewhere to fund their disaster relief, rural development, and poverty programs.
Very much so.
Without an active FCRA registration, that funding doesn't just slow down, it hits a brick wall.
An FCRA cancellation acts as an absolute freeze on foreign assets. Without that registration, an NGO cannot legally receive a single dollar from abroad.
Wow.
Recently, there have been high-profile FCRA cancellations. The dossier notes cancellations for major historic groups like the Church of North India and the YWCA Delhi.
Right, I saw that.
Under Sections 14 and 15 of the FCRA, cancellation is severe. You don't just lose a piece of paper. The government can actually take provisional control of your foreign-funded assets.
When historic Christian institutions lose their funding and their assets, critics naturally cry foul.
Yeah.
They point to this and say, look, this is targeted persecution.
Yeah.
They are starving Christian hospitals of their operating capital.
But the government's defense against that claim is incredibly firm. The Ministry of Home Affairs insists that FCRA actions are purely administrative and financial. They argue this is about strict financial compliance, failure to file annual returns, unauthorized use of funds, and protecting national security. You cannot automatically label an FCRA cancellation as Christian persecution if the organization simply failed to pass its financial audits.
Right.
Thousands of secular Hindu and Islamic NGOs also face immense scrutiny and cancellation under this exact same law.
If the FCRA has been around since 2010, and it's just standard financial regulation, why the sudden spike in urgency? Why is this a massive burning controversy right now in 2026?
Because the landscape shifted dramatically in 2026 when the government introduced significant new amendments and rules that drastically tightened the regulatory net.
Okay, why did they do that?
To understand the why, you have to look at the government's underlying anxieties. India is experiencing massive economic growth, but the state remains deeply concerned about huge influxes of untraceable foreign capital, potentially influencing domestic politics, social dynamics, or even demographic shifts.
So they changed the rules to track the money more aggressively. What do these 2026 amendments actually require an NGO to do?
First, there is now a requirement for activity-specific registration. An NGO can no longer just declare they are doing general charity work.
Okay.
They must detail exactly where, in which specific state or territory, and for what precise purpose the funds will be deployed.
I can see how tighter accounting makes sense from a strict regulatory standpoint. It stops money from moving in the shadows.
They also introduced a minimum utilization requirement. To get your FCRA license renewed, you now have to prove you've utilized at least 10 lakh rupees of foreign contributions over the past 2 years.
10 lakh rupees. For our international listeners, that translates to roughly $12,000 US. So if you're a tiny grassroots organization, maybe just a small village clinic that only gets a few $1,000s a year from a sister church abroad, you lose your license simply for being too small to meet the threshold.
Exactly. Smaller NGOs are terrified of being priced out of compliance. Furthermore, the 2026 rules demand ultimate donor disclosures. The government wants to trace every rupee back to the original foreign donor, stripping away anonymity.
The dossier highlights one specific part of the 2026 FCRA amendment bill that caused a massive uproar. Critics claim the government was introducing a brand new tactic to permanently vest or seize the assets of canceled NGOs, calling it a land grab against Christian properties.
This is an area where we must separate legal fact from hyperbole.
Okay, let's do that.
The 2026 bill did propose rationalizing the mechanisms for vesting assets. However, the legal concept of asset vesting has actually existed since the original 2010 Act, specifically under Section 15.
So it's not new?
No. The provision that foreign-funded assets revert to a prescribed government authority upon cancellation is not a new invention of 2026. Claims that the government suddenly drafted a law this year just to seize Christian property are factually misleading.
Got it.
The mechanism was always there. The government is simply enforcing and clarifying it much more aggressively now.
I'm looking at this dossier, and critics are pointing out that these laws don't exist in a vacuum. You have state-level anti-conversion laws on one side and national FCRA financial regulations on the other. It looks less like two separate issues and more like a domino effect.
Right.
Can you walk me through how a local complaint scales up to a national financial freeze?
Critics view this exactly as a domino effect, outlining a 7-layer systemic picture of suppression. Let's look at a composite case drawn directly from the trends in our research. Imagine a mid-sized Christian medical mission operating in a rural district.
Okay, a hospital that provides free care and is funded by international donations.
Layer 1, the state they operate in, passes a strict anti-conversion law. Layer 2, the hospital holds a free medical camp. A local nationalist group claims the free medicine is an inducement to convert patients and files an FIR with the local police.
Wow, okay.
Layer 3, the police are obligated to launch a criminal investigation and the head doctor or pastor is arrested.
And because of the shifted burden of proof, the doctor now has to prove they weren't coercing patients.
Exactly. Moving to Layer 4, local media amplifies the arrest, and intense social pressure isolates the hospital staff. Now, Layer 5, because there is an active criminal FIR against the leadership, the National Ministry of Home Affairs flags the hospital's Fcra status.
Oh, man.
Layer 6, while the criminal investigation drags on, their Fcra renewal is denied, and all foreign funds are frozen. And finally, Layer 7, stripped of its operating capital, the hospital is forced to shut its doors.
That is staggering. The most brutal part of that domino effect is that 3 years later, a judge might look at the criminal case from Layer 3, realize there is zero evidence of forced conversion, and completely acquit the doctor.
Yes.
But it doesn't matter because the financial lifeblood was already cut off at Layer 6 and the hospital's gone.
The composite illustrates the systemic chokehold perfectly. Even if the government is completely sincere in claiming that the anti-conversion laws and the Fcra are religion neutral, the combined weight of criminal allegations and financial strangulation creates immense administrative and legal pressure on Christian groups.
This isn't just an academic debate about policy. This is a live constitutional battlefield right now. The Supreme Court of India is actively examining these exact issues.
Yes, the Supreme Court is currently tasked with deciding if these state anti-conversion laws violate the fundamental rights guaranteed by the Indian Constitution.
What are the specific arguments?
Petitioners are arguing across multiple fronts. They argue these laws violate Article 14 on equality questioning if minorities are disproportionately targeted. They cite Article 15 on non-discrimination. They point to Article 19 on freedom of speech, which historically includes the right to share one's faith.
Right.
They invoke Article 21, the right to life and liberty, arguing that spiritual choices are deeply private. And of course, Article 25, the bedrock right to religious freedom.
It is a massive clash of two foundational priorities. On one side, you have international bodies like USCIRF and numerous Christian organizations meticulously documenting cases of harassment. They point to the shifted burden of proof, the weaponization of third-party FIRs, and the aggressive Fcra cancellations as a systemic layered web designed to pressure and shrink the Christian footprint in India.
And on the flip side, the Indian government vehemently asserts its sovereign right and its moral duty to protect its most vulnerable citizens from fraudulent, coercive conversions disguised as charity.
Yeah.
Furthermore, they assert their absolute right to strictly regulate untraceable foreign money flowing across their borders to ensure it aligns with national security and domestic interests.
Which brings us right back to that rural hospital we talked about at the beginning. It leaves you with a profound question about the limits of the law. I mean, can a legal framework ever truly measure the authenticity of human faith?
That's the real question.
If a person's life is genuinely transformed because a charity provided them with life-saving medical care, how does a secular court, reading a police report, define the exact moment that profound human gratitude crosses the line into an unlawful inducement?
Yeah.
It's a boundary that legal systems and all of us are still struggling to draw.
And until the Supreme Court of India provides a definitive ruling on where that boundary lies, it's a blurry line that millions of people will have to navigate every single day.
Thanks for diving deep with us today. Keep asking the hard questions.